A constitutional dispute has emerged ahead of the governorship election in Bayelsa State. This follows the disqualification of the candidate of the All Progressive Congress, Timipre Silva, by a federal high court in Abuja. Justice Donatus Okorowo gave the verdict on the grounds that Silva had been sworn in as governor twice and is served for a 5-year term. Arise correspondent Godfrey Shemogai reports.
Justice Donatus Okorowo held that Silva, having been sworn in twice and ruled for 5 years as governor of Bayelsa State, it will amount to a breach of the 1999 Constitution if allowed to contest again on the platform of the All Progressives Congress, APC. A member of the APC had asked the court to order electoral body INEC to delete Silva's name from the list of candidates. He says that by the provision of Section 182, subsection 1b of the 1999 Constitution as amended, Silva isn't qualified to contest because he was elected in April 2007 and May 2008. While citing the Court of Appeal judgment in April 2008 that nullified his election in 2007, the former Minister of State for Petroleum maintains he is within his constitutional and legal rights to contest the Bayelsa State governorship election. In a swift reaction, the Director of Media and Publicity for the APC Bayelsa Governorship Campaign Council, Perry Tukwe, says a team of lawyers have approached the Court of Appeal expressing confidence to overturn the judgment of the Federal High Court. The party says there is a practice directive by the Supreme Court that all pre-election matters be heard in the state where the primaries took place, but in this particular instance, the suit was filed in Abuja. Godfrey Eshamuge, Arise News.
So joining us now on the morning show from our Abuja studios is Liborous Oshoma, a lawyer and human rights advocate. Mr. Oshoma, please lay this bare for us and help us understand what is going on.
Thank you, Rufai. Apart from what your reporter has said, there are two basic issues here. The first one is the judgment that he referred to, and the second one is there's a pending matter also that borders on the qualification of the running mate to Silva. That's Chief Joshua McIver. I don't know if you have also seen that video, if you have also heard the report, where Joshua McIver admitted clearly that he was convicted sometimes in 2004 for act bordering on terrorism, and that he didn't serve that jail term. He jumped prison. He broke prison when MEND came a month and 1 week later to release him from prison. So for this one, I think APC might be challenging this ruling on appeal coming under Section 29, subsection 5 of the Electoral Act that has to do with who the local standee to file, and then also the time within which the application was brought. But the main issue for me, really, after looking at the two issues, it is the issue of the conviction of a running mate, whether Nigerians should be compensating people who had been convicted with political office. We have one issue of certificate forgery hanging, debating, hanging on the credibility of Nigeria and the president as we speak. And yet, also, you have another one in Bayelsa where somebody who's been convicted and sentenced by the court and who also admitted to breaking jail is a candidate, in an election in APC. I don't know.
What's the precise detail of that McIver's case? Can you give us the precise detail? And let's talk about the judgment and all of that as regards the McIver case, please. Yeah. Okay, then.
So in charge number FHC KD 119C/2004 between the Federal Republic of Nigeria and Joshua McIver. The charge read that you, Joshua McIver, and others at large on or about the 17th of April 2004 in Ologbobiri community, southern Ijo, Bayelsa, within the jurisdiction of the Federal High Court, dress yourself in military camouflage and attack Tebidaba Ajib oil flow station with military rifles Would he tend to overrun and coerce AG Petroleum to enter into an agreement with you? So, in that charge, that was the sole charge in that matter, and the court, the Federal High Court, ruled that the convict was not remorseful and that to serve as a deterrent against future occurrence, and that he was subsequently committed to 10 years imprisonment. In his words, the man said, yes, he committed that act and he was not remorseful. But that he had his plan, that he was supposed to be, that MEND was formed and MEND, wanted him to come head the Bayelsa arm of MEND, and that a month later that MEND broke jail and rescued him. And that so if you say that he committed jailbreak, that he proudly committed it, and he's not remorseful about it. So that is a conviction. We're not talking about a crime that was committed that had not been convicted. That's a conviction. You remember in the last election, it was whether the names, Degi Eremiyo and all of that. And now also you're having somebody who proudly had admitted to being convicted. When I saw the video, I had goose pimples. Somebody who had admitted to being convicted by court and who had not even served the sentence is being feeded as a running mate. And so for me, anyway, I won't go deep into the matter because the matter is in court. But for me, the challenge here is that you don't even need to go to court for the police, the DSS or the National Security Advisor to immediately arrest such persons and hand them over to the correctional prisons, correctional services to serve their sentence. Because this idea of go to court is suddenly gaining traction under APC. And it is, for me, it is very sad and unfortunate that these people when they were in opposition, these were some of the things that they accused the PDP of doing. And now they are in government. It seems worse that somebody who had been convicted, and if you even see the arrogance with which this man was talking about, yes, I proudly did this thing, it shows that we do not even have respect for our laws. And I also think that quickly, this is an opportunity for the judiciary also to stand tall, because the judiciary has been in the eye of the public, had been battered for too long over this election petition. And now we are building to another election petition in another election in 3 states in November. And then all of these things are coming up. It's quite unfortunate, really. And I think that the APC should not just take my words. They should investigate. The video is online. They should investigate and do the needful so that we do not further ridicule Nigeria in the eye of the Committee of Nations.
All right. Thank you very much for saying this. Now, I want you to tell us, from a legal perspective, I mean, Mr. Timipre Silva has his case to answer with regards to whether he's even eligible or he still stands disqualified because of the time limit. And now we have his deputy in the spotlight in terms of Mr. McIver. What is the implication of this in terms of, do they even have an opportunity in terms of the APC fielding candidates for the November 11 elections? Because even if we don't get it on Mr. Silva's part, Mr. McIver on his end has his own case to answer. And out of curiosity, my question would be, why has it taken this long for this case to emerge in terms of why didn't the party at party level, why didn't they do any background or preliminary checks? Is it admissible that his lawyer, that Mr. McIver's lawyer, said that it is statute bound in terms of 10 years? Does it still apply since he didn't serve his term, the fullness of his 10-year term? Or what would you say on this?
We would be talking about, thank you very much, we would have been talking about 10 years if he had served his term. Since he didn't serve at all, it is still presumed that this man that was convicted, that broke jail, the correctional services are still looking for him. And also, during this amnesty program in the Niger Delta, a lot of people blanketly, hid under the cover of, yes, amnesty program, and started parading themselves as people who were granted amnesty. But if you look at Section 175 of the Constitution, it spells out the provisions and grounds for granting amnesty. And so, the Joshua Darie and Jolly Yame that were granted amnesty, every layman in Nigeria knew the procedure that were followed. Amnesty or pardon, we all knew the procedures that were followed. But in this case, when there is no gazette and nothing like that, but it's also tell you the political environment that we operate in, where people who, once you join the ruling party, you remember my big Oshoma, Senator Oshoma, once said that if you join the ruling party, your sins are forgiven. And so I also want to presume that maybe this is what is playing out. But unfortunately, the fortunate part for me is that this is coming up before the election, because after the election, if anything had happened, we would have been chasing, maybe going to Kaduna or going to Toronto or wherever, Chicago. But in this case, this is before the election. So there's still time for the party to do the right thing and distance themselves from this act of criminality admitted to have been committed by their member. And also, on the issue of Section 182, that's, will be for the court to decide, because, like I said, there might be some hurdles that the applicant might want to cross. But on the issue of criminality, there are no hurdles. We don't even need anybody to go to court. For somebody, even let's assume that the party were not aware. The moment the man came out in the gathering of the political party to confess that, yes, I was convicted and I broke jail, at that point, immediately it becomes a police matter. Immediately it becomes a DSS matter. Imagine if this were just anyhow person who does not belong to a political party. If he would have been declared wanted by the police with large posters everywhere and a screenshot, that he's wanted by the police. But today, because he's a member of the political party, he's been feeded, they pretend not to know. And so that is why for some of us who are interested in public interest matter, we are drawing their attention to it, that if you do not know, the police now we are telling you, the DSS we are telling you, the Office of National Security Advisor, we are telling you that you don't even need a court order, because a court had given the order. And I have also read out the charge and then the suit number. The records are there at the Federal High Court in Kaduna. So you don't need a court order to make an arrest. So that at the end of the day, it does not look as if when tomorrow this person wins an election or the court now say, well, in the first place, you were not qualified to stand for an election. It looks as if court are now the determinant of election outcome. So, and that's why it is timely now. And also we pray the PDP as a political party. And maybe they probably don't know how to play opposition. This is the time. Yes, that's the video. This is the time for them to begin to learn to play opposition party politics and take up this matter and ensure that the right thing is done. But unfortunately, for some of us, we can't fold our hands. We want a society that our children will be proud, to inherit. You work and then you'll be rewarded. Not a society that will be rewarding with criminality, with political offices. The implication of that is that you're telling people who have the capacity to carry arms that are not carrying arms that criminality pays, that all you need to do, even if you are convicted, that you will be compensated. It is already bad enough that government is granting amnesty to political office holders that have corruptly enriched themselves after conviction. It is also would be very bad if, as we speak now, the next thing government hurriedly, package amnesty for this same man. It's quite unfortunate, and Nigerians should not, gloss over this.
Okay, Liborous, yes, about the Makava case, I guess that's fairly straightforward. But in the matter involving Chief Timipre Silva, the party in Bayelsa said they are going ahead with the campaign and they are going on appeal. What are their grounds? That, look, this is a pre-election matter, and that the man that went to court, he doesn't have locus. It's not even, he didn't take part in the primaries. Yes. 2, they're saying that, the matter was filed out of time. And then 3, they are saying the practice directive is that, look, that matter should have been heard in Bayelsa, not in Abuja. But my question to you is, even if...
I can't hear you.
Oh, but I can hear you. Can you hear me? Hello? Oh, we seem to have lost audio connection with him. Yeah, okay, I was going to ask him. Look, since it's a joint ticket, right? Will he say that that ticket is defective per se? As we saw in Dege Remi Onye case, in this same Bayelsa, the person who had issues was the deputy governor. And then a day to they are swearing in, you know, the court said no, it's a joint ticket, so it is defective because it's not one man going. The constitution is very clear, you must have a deputy. And if your deputy, you know, is not qualified, then you two are not qualified. But do we have him now? Liborous? Okay, I think we just have to thank Liborous Oshoma.